Good morning, good morning, good morning to all. It is February the 7th, and we are here talking about, oh God, I'm going to breach my new build agreement. What do I do? Before I get started, let's do our normal caveats if you do not mind. First, note that all of the forums that we actually all partake in on Facebook are private and only primarily involve our colleagues, but our recordings are public. And these will be placed in any number of places. So please be aware of that, and please temper your swearing accordingly. Second, we're at 13,000 people. Yay, we're at 13,000 people in our main group. And of course, there's a host of other groups. And I suggest strongly that every single one of you join these other groups. There is now collectives, there's strategies, there's the legal forum, the subgroup of ours that is the landlord tenant. Of course, the Tressa group is still being run strong. And of course, there's the primary group here, which is here to answer your legal questions. So that being the case, please invite your professional friends. Please make sure in the understanding that the more the merrier. And also we are all stronger when we are together. Okay, that being the case, we have a lot to discuss. And let me start with the basics of the problem, if you don't mind. And then from there, we can kind of turn our attention to what we're dealing with as a matter of course. So the essence of the problem that we have is that there is a price differential. Sorry about that. I apologize. I have an office dog. There is a price differential that exists presently between new build product and between resale. And that price differential is not going away. Yes, I know the market is picking up. Yes, we've all heard about the 85 offers and everything else. But if you're actually examining what those offers are, I'm just talking about the business reality before I talk about the legal solutions. If you take a look at what those price differentials are, if you take a look at what those offers are netting, the 85 offers and the 61 offers and the 51 offers, we're seeing them over and over again. If you take a look at what they're actually netting, what they're netting is something which is very much similar to what the market price should be if these things were priced properly in any event. And what the market price is showing is that new build products stemming from 2019 through to 2021 is still overpriced by an average of approximately 20% to 25%. And that price differential is not going away the way it has in previous years, where prices would go up hugely very quickly over time, eradicating any incentive really to walk. And so what we now have more and more is we have circumstances where we have closings that are taking place, which will culminate in the 2025 year, because a condo cycle is a 5-year cycle. So when you're in 2025, you're looking at product that was signed for in 2020, 2021, and 2022 that are closing. That is to say, peak of market. 2025, 2026 is when you're going to have a whole bunch of products that are coming to the market that are closing, and where the price differential of that product, the market hasn't caught up to it. And as a result, when people are closing on things, they're saying, well, hold on, this is a huge problem for me, because if I close on this, I'm going to be underwater just paying the purchase price. And that was never really the case. And so more and more people, particularly those people who are real estate savvy, and for those people who are not living at these products, are now coming to their lawyers. And on a daily basis, I see quite a few lawyers in this crowd right now, and they can all attest to this. We are having endless conversations with people around the idea of what can I do? What can I do? How do I deal with this? And the truth is, there is an actual role for a lawyer in that process, and that's what we're going to be talking about today. First, let me start with the basic preposition that I've said quite a few times, but I'm going to say again because I really don't think it permeates consciousness too much until you hear it. It is illegal to go 101 kilometers on a highway that is noted as 100. Why? Because the Highway Traffic Act says you can't go past 100. Doesn't matter if you're having a baby or anything else. These are all excuses, but these are statutory offenses. Can't do it. Can't trespass on someone's property. There's the Trespass Act. It is illegal to do something against which the legislature has said you cannot do something. Whether it's in the criminal code or whether it's just a normal statute, it's illegal. It's contrary to the law. There is no law that says you must abide by a contract. None. There's no Performance of Contract Act. There's nothing in the criminal code that says you must do this. In fact, it's perfectly legal to breach a contract. There's no issue with it at all. The issue, from the perspective of the person breaching, is that there are consequences, known consequences, consequences predicated upon the common law and upon the idea that we have 600 years of history or 1,000 years of history where people have continually breached contract and where judges have said there are consequences to breaching. And in the instance of someone who is not performing a real estate contract, the consequences are known too. And undoubtedly, every person who's here knows what those consequences are. The consequences are the loss of the deposit and the delta between whatever it takes for the builder to actually mitigate its loss and the original purchase price. So you may ask yourself, well, okay, Mark, why are you starting there? Why are you starting with what's legal and what's not? And the answer is because the fact that it's not illegal means that a lawyer can coach their clients through breach. I can't, when the client calls me and says, I'm having a baby, I'm traveling down the 401, can I go 101 kilometers an hour? I mean, by the way, that's only happened 3 times in my career. But when that happens to you as a lawyer, you do not then say, yes, you can, because of the circumstance. Right? What you do is you say, stop asking me as a lawyer, go call your friend, they'll give you the right answer and get to the hospital. But the lawyer has to say, no, you have to go 100. But when someone comes to me and says, I need to breach a contract, I can say, okay, let's talk about how to breach the contract. I can be your guide as a lawyer through that. There's nothing illegal in what we're doing. Okay? So just so you're aware, the job of a lawyer is to counsel their clients through a contract, including breach, which has repercussions. And as a result, when people come to me and say, Mark, I have problems, I am in need of advice as to what to do, I can give that advice with very little issue. So I'm going to pause for a second. I'm assuming what I said is very straightforward, but I'm just going to make sure everyone understands where we are so far in our fun time today. All right, great. So the first thing that we do as lawyers, and I'm going to take you through this the way I would every single, I get a call a day at this point and have for the past 3 months, literally a call a day. I'm breaching, what do I do? Or I'm breaching in a couple of months, what do I do? How do I prepare? So the very first thing that we do is we basically say, thank you very much. Let's try to assign this. Okay. And the first pushback you sometimes get is you get people who say, but my contract doesn't allow me to assign. And at that point, you basically say, that's great. Please assign it and make it conditional upon builder consent. Understand that you may be breaching your contract because it says you can't advertise anywhere except for MLS, especially on MLS, but you can't advertise anywhere. Make the bill that you can have a discussion. You're going to breach anyways. So you might as well go ahead and place this on an agent-only forum post or something else. Try to get an assignment. And don't worry about what the contractual terms of the agreement are, because the parties, the builder and you, can at any time later agree to amend and to get an assignment. And as some of the agents on this forum will attest who deal with our office regularly, merely getting a no from a builder is not a no, because once you get that no, you then basically start with, that's great, but please be advised about the hardship of my client. And they're like, no. And then you say, you don't understand. My client was a Vietnam War vet whose family was carried away by 6 wolves in a raging river and, ultimately lost an arm saving 6 babies from a burning building just last night. You give the sob story, and the builders, almost 99%, eventually back down despite what's in the contract. So the first thing you really want to do as a lawyer is you want to say, let's ourselves mitigate this loss through the assignment process. Invariably, your clients are going to say, can you ask for a mutual release? And because we're obliged to accept their instructions, you often do it, even though you inform the clients that there's 0 chance that the builder will accept it. And why would they? They have your deposit. I mean, there's no advantage to them in giving a mutual release at all. Though a smart person that I once had in my office said, listen, I'll give $50,000 right now in addition. There's 2 years to closing. I'll put $50,000 additional down if you give me a mutual release. And the builder is looking like they're going to say yes to that strategy. So there are strategies you can employ where you can try to get a mutual release. It's not usual that they agree. It's much more normal for you to be able to secure an assignment if you can. The problem we have is that assignment markets are illiquid, or not so much illiquid. They've started to move actually since December. As I see Elena's on this channel, Elena will attest, because the amount of assignments that are now coming in is tremendous. So the assignment market has now started to move. The problem, however, is still the fundamental business problem that I talked about at the beginning, which is that priced product from 2020, 2021 is still 20% above market. And so any assignments that are coming in at losses. Or if you have a very high price product, if you're stupid enough to buy for $1,600 a square foot in Moss Park or whatever it is, then no offense to anyone who did that, then fundamentally, you're still not going to be able to assign it. And you're going to be turning to me and saying, okay, well, what I need to get out. So let's assume that the assignment route is not available. Let's assume that your mutual release route is not available. Let's assume that you are truly in a breach position. What do you do? Well, at this point, we have to now turn our attention to what it was I was talking about, which is the fact that that a lawyer can guide you through breach. And guiding you through breach involves doing something that lawyers hate, which is called math. Now, for the lawyers on this channel, Excel is the green one. And as a result, I'm going to pull up the green one. It's not the blue one, it's the green one. And we're going to do some basic math together, because showing your clients what the end result looks like is critical to actually discovering how to conduct yourself. And what you're going to find, I'm going to give you a spoiler alert, what you're going to find once we go through this entirety of this process is that in almost all instances, it makes sense to breach financially, not necessarily from a risk perspective, but financially. So let's take a scenario that just hit my office the other day. Let's say that we have a purchase price of $1,500,000. That's how much the original agreement was signed for. And the sale price, similarly, is going to be $1,275,000. Now, how do you get the sale price? Well, you turn to your clients and say, give me a worst case scenario. Everyone, the amazing thing is everyone says, oh, I don't know what it's going to sell for. And then you're like, yes, you do. It's your real estate. You're tracking it. What do you think it is? And they all know in their heart of hearts what something is worth. If they didn't, they wouldn't be having a discussion with you about to breach, because they may have an upside. They know what the downside is. They've thought about this before they've come into your office. So you basically say, conservatively, what's the lowest you think this would sell for? And they tell you, okay, 1.275 in today's market. So now you have your parameters. A deposit has been paid here of, say, $150,000. Let's just call it some 10%. And as a result, these same scenarios present themselves. Sorry, let me just quickly get this. Equals this, equals this. This is the same. There you go. So we have these two same scenarios, whether we're proceeding forward or we're breaching, because this is the starting scenario that presents itself. Now, let's say that we were to proceed forward, because you really want to draw out the two scenarios for your clients. And you want to say, okay, let's for a minute assume that you don't want to face litigation and you want to get this builder off your back. Because those are your two options at this point. You're either going to breach, if you can't assign, and if you can't get a mutual release, you're either going to breach or you're going to go forward. Those are the two avenues. So let's explore both avenues. The first is, what happens if you're going to go forward? Well, if you're going to go forward, you're going to have this $1.5 million. Your 1,275 is your sale price eventually, and your deposits paid is 150. That's the same in both instances. Your holding costs. So let's talk about that. If you have, let's leave that. Let's move on for a second. LTT. So first, you're going to have your land transfer tax, and I'm just pulling up a browser that you can't see, and I'm just going to do this very quickly. Land transfer tax. So I'm going to assume that this is in Burlington, Ontario. Let's make it Toronto. Let's make it fun. Okay, so on 1.5, we're going to have approximately $50,000 in land transfer tax. Because remember, for those of you who are not from Toronto or practice in Toronto, there's double land transfer tax here. For a job, and it's 4% above $400,000. For adjustments on this, well, it's reasonable to assume that adjustments on a $1.5 million condo, condos are usually higher adjustments than houses. But let's just for now assume it's between $15,000 and $25,000. So let's just assume that we're looking at $20,000. Your lawyer can do a more thorough review, but the essence of the discussion points remain the same. Your legals are, of course, as much as we can charge because we're lawyers. But let's just for now assume that your legals are going to come on a 1.5 on a purchase to, let's say, $4,000. That's inclusive of that's inclusive of title insurance, because title insurance goes up as the purchase price goes up. And then we, of course, I'm going to leave sale commission for a second. So if that's the case, then what we now have is we have a scenario where we have to come up with a whole bunch of money. And the whole bunch, and so let's see what the, hold on one second. I'm going to move sale commission here. All right. And so we are going to have a mortgage. Let's do this. I'm going to remove holding costs for a second. Sorry, guys, I'm just doing it with you here. So mortgage. So let's say that you're securing a mortgage on the balance. So you're going to get this minus the deposits. Let's say that you're getting 90%. Let's say you're getting 80%. Excuse me. So it's that times 0.8. So that's 1.2. And so on a 1.2, we're going to just assume on an interest only basis, because that's going to be the true cost. We're going to say times 7%. Times 0.07. And so that gives you your annualized cost. And because I'm assuming that you're going to hold on to it for only 6 months, it becomes $42,000. Why am I assuming 6 months? I'm assuming 6 months because if you are trying to actually buy and get rid of the product, then I'm assuming 6 months is the amount of time it's going to take to close on the product and ultimately sell it through to completion. Seems reasonable, 6 months. So you're going to have mortgage interest costs of $42,000. Okay, because of the 6 months. Now the interest rate on money is for something else. I'm going to say interest rate on private money. Okay, and I'm going to say interest rate on bank money. All right, so this is going to be, what did we say? We said 7%, sorry. So we're going to say 7. Just give me 1 second, guys. It's doing a spreadsheet in real time. It's fun times. Hold on. 7%.
I don't. My laptop.
Okay, so let's do this. So that E times this divided by 12 times the amount of months. There you go. Okay, so excellent. So far, what we have is the purchase price, the sale price, the deposits paid, the mortgage interest costs at 6 months, right? Because that's what we're talking about, and using bank financing, then we have the LTT, the land transfer tax, the adjustments, and the legal fees. And so our total costs are, let's do it. So they are 1.5, our total costs of holding this are our deposits paid. Oh, wait, there's one more thing we need. Sorry, hold on, insert. Balance payable. So we're putting down 80%, we said. So we're going to have 1.5 million. And so we need another balance payable of 150,000. And so we have mortgage costs using bank and mortgage costs of down payment. Because, to be clear, the $42,000, just to be clear, the $42,000 that we have is the cost of 80% of $1.5 million. But in addition to that, we're also losing out on the $300,000 in interest that we have had to put down as a down payment, right? And so we have equals this plus this. 1 second. This plus this times, let's say 7%. And then we divide that by 2 because you're only holding on to it for 6 months. All right, so now we know what our total costs of actually closing on this are, don't we? We now know that what we've had to pay for this is 150 plus 150 plus 42,000 for the mortgage of 6 months plus 10,500 for the lost interest on the $300,000 plus your land transfer tax plus your adjustments plus your legal fees plus the purchase price. So the total amount, sorry, 1 second. I apologize. I'm sorry. I made a mistake. I apologize, guys. Sorry. Equals the purchase price plus, plus the mortgage interest costs, plus the cost of the down payment interest, plus the LTT, plus the adjustments, plus the legals. That's what it is. Yes, I do. So we get 1.626500. That's the true cost of this product if I'm holding on to it for 6 months. And then I need to figure out what the net cost is if I actually sell it within 6 months. So let's continue our analysis for a second. So our sales commission is going to be the sale price times 0.05 times 1.13, because you have to pay HST on it. So we have to pay 72,037 in tax. And as a result, our sale price, we already know. So our net becomes this. It becomes our net loss effectively, because so we now have so it becomes equals this plus this, because those are our true costs. So our cost of getting into the product plus our cost of sale, subtracting the amount that we resell for, and our net loss becomes 400, just 1 second, becomes $423,537.50. That is if we close on the property. I'm going to pause for a second because I did a lot of junk back and forth as I was figuring it out. But this is what I do with a client every single time. Does everyone understand on the proceeding forward basis how I derived what their true cost is based on the assumption of what their sale price is and the assumption of holding on to this product for a 6-month period and the interest rates that are in play accordingly? Does everyone get what I said? Please unmute yourself and ask your question if you don't understand how I derived the net loss here.
So Mark, I do get how you got to this number. I'm just wondering, for your 42,000 mortgage interest cost, would there also be a penalty to pay that?
No, because if you do that, you're going to, no, because if you're doing that with your lawyer is going to say, look, if you're looking to sell within 6 months, let's arrange an open-ended mortgage for the 6-month period, right? And so the interest cost may go up because you may have to get a private mortgage or you may have to get different terms. 7% may be a bit too light, but honestly, what we're talking about is a couple of $1,000. It's not going to affect the overall math. So instead of 423 and maybe 410, it's not going to really affect the overall strategy. But yes, you're going to arrange for an open mortgage because your goal in getting into this product is to get out.
Gotcha. Thanks.
No problem. Anyone else have any questions so far before I move on to what it looks like to breach? No, we're good? Okay. That being the case, let's continue our, as my French teacher. Yes, go ahead, Cacti. Go ahead.
What am I waiting for?
All right. I'm not sure who is speaking, but is that a question or not? I guess not. Okay, fine.
Mark, a quick question.
Yeah.
Will they be paying land transfer fee on the assignment also?
No. The assignee, the purchaser pays land transfer tax on an assignment. On an assignment, you basically make back, it depends on what has been agreed to by the assignments. But assuming that the assignment price is the same price as you had originally paid, then you walk away at zero.
Okay.
Okay,
Thanks.
very good. Now, let's talk about what it looks like to breach, okay? Because this is where things get interesting. So far, everything I've said, hopefully you understand and you know. Let's talk now about what this looks like to breach. So breaching is actually a much, much simpler calculation. You know that you're going to lose your deposit, right? So sorry, just 1 second. Let me insert this and 1 second, please, guys. So let's talk about what your loss is going to be. So your loss is your deposit. So that equals 150. You know you've lost it. And balance. And the balance is this, equals this minus this, 225. And of course, that is not what the loss is. The loss is 225 minus the 150, right? Because they already have claimed the 150. So what it is they have 150 plus $75,000. That's what they're able to claim so far. Now, they're going to have to take pains to mitigate their loss for sure. They're holding on to a $1.5 million product. So what we're looking at is interest lost. And so we're saying, okay, 1.5 times, and we're going to say private money because it's a builder. This divided by 12 times 6. I'm going to assume it takes them 6 months to mitigate, though it usually doesn't. So their interest lost is going to be $90,000. And they may very well, they usually do not actually claim, in my experience, they are not claiming a further realtor fee. Litigators may choose to disagree, but I've seen it be fought because what happens is the builder, and I've seen this in case law, the builder has an obligation to reclaim the previous commissions that have been paid to the other brokerage. And given that that's already part and parcel of the $1.5 million fee, there is a valid defense if defended properly, which says that they shouldn't be paying the commissions again. They should be reclaiming it from the initial party and then allocating that new commission. So generally you can get away with no commission. And as a result, or no further commission, excuse me. And as a result, the loss equals this plus this plus this. And lo and behold, you'll see that your net loss is $315,000. As opposed to $423,537.50. And of course, this does not include a whole range of other considerations that we then walk our client through. So before I do anything else, is this clear what I've put out on my spreadsheet? Before I go anywhere else.
Yeah, me again, Mark. Would there be legal fees on the right-hand column that need to be paid as well? Are you compensating?
Yeah, that's true. We can put in legal. I mean, it's going to be a summary judgment or it's going to be something very quick. So the legals are not going to be astoundingly high, but let's put in $10,000. That's fair. Yep. So let's add that as well. It's a good point. Again, you're filtering around the edges. You still have $100,000 that we're playing with, right? Now, here's the interesting point. I'm going to stop sharing the screen for a minute because I want to go back to what we do. So the interesting point is that at that point, the job of the lawyer isn't done. So we've plainly shown that there is a financial advantage, largely because of the adjustment cost, the land transfer tax, and all of the ancillary stuff and the commissions. There is an ancillary advantage to, there's a clear advantage to actually just breaching your agreement. And sometimes it's much clearer than this. I just had an example where there was a $300,000 difference in breaching as opposed to not breaching. Now, there are some disadvantages to this too. First off, the builder is in control of the process with item number 2, where there's a breach, as opposed to number 1, where you're in control of the process and you can determine what it resells for and everything else. Also, there's the uncertainty of litigation. But litigation comes with its own benefits for you as well, because after all, so long as you put up any sort of defense, and the defense can be made on the basis of the damage claim alone, because whatever the builder claims as damages you can fight, you will have the opportunity to actually be there at pretrial and negotiate with the builder at that time and throw money on the table and say, okay, I know your claim is for $325,000. We don't agree with the damage claim. We're going to put up a good defense to this. So look, we'll give you 250. Let's walk away. Boom, you've just saved $75,000. $75,000 you would not have saved in the event that you are going the closing route and taking this on yourself. Now, a further discussion is then had as to what the actual procedure looks like should breach takes place. Because of course, if someone is contemplating breach, then they should understand what the ramifications are. And they always say the same thing, which is, well, okay, how likely is it that the builder will sue me? And as a matter of course, you should be preparing for the fact that builders will inevitably try to sue you. Now, the first thing a builder does when they are going to sue someone is see if they have assets. And the easiest way to do that, who wants to volunteer what the easiest way to do that is? What's the easiest way to figure out if someone has assets in Ontario? You're all real estate agents.
Geo.
That's right, Geo Warehouse. You throw in someone's name and you check out if they're on the land registry. No lawyer can recommend to their clients to remove assets from a creditor or potential creditor in Ontario. Remember how I said that if you drive 101 kilometers down the highway, it is illegal? There is a legislative statute called the Conveyance and Assignment and Preference and Assignments and Preference Creditors Act. I forget what it's called exactly, but whatever it is, there's legislation that says that you are not allowed to move assets or shield assets in anticipation of creditors coming after you. Now, I mean, don't get me wrong. Law is one thing, practical is aside, and everyone looks at you and says, to hell with you, I'm absolutely moving assets, who has a head on their shoulders and says, thank you very much. I'm going to get this into anyone else's name but my own so that it's not searchable, and there we go. But there's no lawyer who can counsel you to do that. Remember, I'm not counseling anyone here. I'm just having a talk. Otherwise, I wouldn't be talking about this with clients. But, you know, realistically, the first thing someone is going to try to do is make themselves effectively asset proof in the form of when they go back to the lawyer or the creditor and they basically say, look, I don't have any homes, I don't have anything else at pretrial, they won't have any credibility if you search Geo and they have 3 homes under their name, right? They're going to say, screw you, I'm not taking your $75,000 discount. So people are going to naturally figure out that they're going to want to become somewhat asset proof as they go, though a lawyer cannot recommend doing that at all. This isn't a nudge, nudge, wink, wink. I'm speaking to the lawyers on the channel. Do not say that to your clients. It is illegal, and you cannot counsel people in an illegal activity. And so don't help your clients breach a contract because it's not illegal by further engaging in illegal activity and explaining them how to actually avoid creditors, because you're not allowed to do that. Again, they'll figure it out themselves. So you leave it to them. And at that point, they'll say, well, am I likely to be sued? And the answer is probably. Most lawyers do not sue, at least in my experience, do not sue immediately upon breach, because of course, upon the discovery of breach, which happens on the day that you basically don't come up with your money, or you announce anticipatorily that, thank you very much, this is not going to close. At that time, they have 2 years to sue. And because they have 2 years, most builders mitigate their loss. And this is another critical component and another reason to think about breaching an agreement. I know that you don't usually hear this, like a lawyer sitting there saying, you should be thinking about breaching an agreement, but it's another consideration you need to think about. Because consider this, in the event that the builder does mitigate its loss, and let's say that the builder takes a loss of $50,000. Well, boom, you've just hit payday. Why? Because they're not going to sue you for $50,000. They're going to sue you for $35,000. And they're going to sue you for $35,000 because that happens to be the limit of the small claims court. And suing for $50,000 involves a whole lot of extra damages and legal fees and procedures that the small claims court does not. And so if you're hovering somewhere around a 35 or just above a 35 mark, You can easily cut the amount you're actually going to pay down to the builder by 35 simply because they're going to sue you in a venue that only accommodates a $35,000 lawsuit. Boom, another advantage, right? Similarly, there is a requirement to explain to clients not to be passive in the breach process. It is the case that there are times to speak up and there are times to lay low. It doesn't matter if you lay low when they're sending you your breach letters because you're objectively in breach. Like the fact that Brady's is sitting there saying we're going to come after you with a 10-foot garden hose and you know whip you to hell. You know, there's no response to that. You have breached your contract. You're done. But it sure as heck makes sense to respond to a statement of claim levied against you, not because you have any sort of defense to the merits of the claim, but because you have a defense to the damages. Now, let me pause and explain the litigation process so that the lawyers on this channel can properly counsel people for what is coming in the event of breach. When someone sues you, they are hoping for one of two things. They are hoping that the suit is so simple, straightforward, that they can achieve what's called summary judgment, which is a judgment immediately. There's no triable issue. Just give me judgment, judge. Or they can achieve default judgment. That's even better. You don't file a defense. Default or summary judgment. Those are the hopes. Those are also the hopes, by the way, in a power of sale action. If you can defeat default or summary judgment, if you can put up a defense, then it needs to go to trial. And if it needs to go to trial, there is a period of a year before which a judgment can be rendered, and there's a whole bunch of defenses that need to be considered. And basically, it's an agitative thorn in the side of the builder. And accordingly, the builder may, at pretrial, be more than willing to take a haircut to just get this over with and a judgment ascribed. And so the job of someone in breach is to really think up, A, if there's a defense, which usually there is not, but also to prepare to defend on the basis of the damage claim, because legal cases have two different holes, if you will. They have two different items. First is whether there's a legal and actionable wrong. And to that end, there is a legal and actionable wrong. It's not an illegal wrong, but as we discussed, common law has made it such that a contractual violation has repercussions, and a court will find as such. But the very fact that a court found that there was a legal wrong does not mean that there is damage or that the builder is suing appropriately for those damages. And defenses can absolutely be made as to the damage claims such that you are running the gambit and forcing trials on damages where experts have to be called and where fundamentally market values have to be assessed. And there are a lot of things that a good litigator can kind of muck up with regards to damages. And the point here is to force this to get not to victory at trial, but to trial. Because if you have it as something that is not a summary judgment and not a default judgment, you have negotiation leverage over the course of the year and may be able to strike down the amounts that are due and owing. Now, you'll note that everything I've just talked about involves copious amounts of risks and unknowns. And a lot of people aren't good with risk and unknown. A lot of people don't like the fact that the builder can be in the resale seat. They don't like the fact that they're going to be sued. They don't like the fact that ultimately they don't know what's going to happen and that it may just be a concacophony of terribleness for the next 2-3 years. And so a lot of people say, screw it, I'm going to take my $423,000 and my hit and not take my $325,000, possibly even less, depending on how this goes. Why? Specifically because these people are saying, thank you very much, I'm risk adverse. And that's cool. That's perfectly fine. The job of the lawyer is not to tell them which of these two angles to take. The job of the lawyer is to properly describe thank you, Greg. Fraudulent Conveyances Act is one of them. There's two acts. The other one I'm thinking of, if you can just look it up, is the Assignment and Preferences Act, I think is what it's called. Sorry, Greg just wrote me a thing saying it's the Fraudulent Conveyances Act that makes it illegal, but it's a different one that I was thinking of as well, because it's not fraud. But it is fraud. And anyways, Greg, if you could just look up the act, I'd appreciate it. So the job of the lawyer is to properly detail for people what the repercussions look like, and then predicated upon their individual proclivities and their assumption of risk, have them make an educated and understood decision as to how it is they wish to proceed. The job of the lawyer is not to say to people, well, you signed a contract. What do you want? Damages. That is not a good way forward to help clients, right? Because they already know that. They know they're screwed. They're coming to you anyways. Give them something tangible. And this is what lawyers can do. We spend, honestly, 1 to 2 files a day now, just explaining the math and showing people what this looks like. And the interesting thing, guys, is as realtors, you're in a position to share math as well. You don't need to say, listen, I'm advising you. You certainly do not give advice as to whether or not to breach. Your advice is get to a lawyer, please. But you can explain to people what it would look like, as an example, to close on something and to resell. You do that all the time anyways. That's what you do. When you are sitting there and someone says, I'm thinking of selling and purchasing, you say, okay, well, let me tell you about land transfer tax. Let me tell you about adjustments. You do that. And you can help people understand that as well. Now, only the lawyer should be giving advice as to what to do next. But that doesn't mean that you don't have information that can color things in as well. Thank you. Wesley says the Assignment and Preferences Act. That's what it is. That's what I was looking for. Thank you very much for that, Wesley. Okay, so it's now 10:43, and I have said what I need to say about this. I'd like to open it up for questions, and it's, I guess, 10 minutes shorter than we usually are, but, you know, I don't know about you. I'm kind of sick of the sound of my voice, so let's turn it over to the audience. Unmute yourself, ask your questions. Very happy to answer anything I can. And of course, we have amazing lawyers on this channel as well. I see Sean is here. I see Greg is here. Wes is here. You know, any of the lawyers who are here, you know, feel free as well to give the benefit of your opinions, because you guys are doing this as much as I am, and you know this as much as I do.
So, Mark, and I arrived late, so I apologize if you did cover it, but I didn't hear you cover it. One of the factors that wasn't on your spreadsheet, though, is this concept of you know, if you take the $400,000 loss as opposed to the $300,000 loss, but you own it, you know, or you've assigned it to someone who owns it, who's getting the benefit of the market recovery? And some people have the ability to do that, some people don't, and it goes to mitigation and stuff. So it just you know, and I think Sandra Jackson will agree with me. You know, my default is always find a way to close, find a way to close, find a way to close. And you just have to be careful how you position this. It's not a black and white choice between default and do nothing and lose 400 or lose 300, or close and lose 400, because the unsophisticated buyer out there may misinterpret that. So,
Totally.
so there just is that interpretation of, you know, we're all in this business and we understand it at a certain level. Our clients don't always understand it at that level. So yeah, just be careful.
You're totally correct, Wes. You're totally correct about that. My point in bringing this up is not to say that there is that you should opt for a choice merely because of dollar value. My point is to say there is a choice, and we need to start opening our eyes to the fact that there is a choice that needs to be made. And you're right, the individual proclivities of every single client that you have will play into the discussion. The ability to take a loss, the ability to hold on, the ability to control the process. You know, like if you think about the power of sale process, which I know you and I engage in all the time, you know, the secondary lender always tries to buy out the first, specifically so they can be in the driver's seat for the actual litigation process, because there's so much advantage to doing that, which is the same advantage you would derive if in fact you do close. All of these things are not things I discussed in any sort of great detail, but all of which need to be part of the discussion. And again, a reason that a knowledgeable lawyer should be having this discussion with the clients. My point in bringing this up today is to say there is a real choice that needs to be discussed. And I don't feel that other people in this industry are even discussing the choice at the present time.
No, fair. And then the other thing about the Assignment and Preferences Act, which is one of my favorite pieces of legislation, for those unfamiliar with it, there's a clause in this legislation that says, you know, if you're on the eve of insolvency or bankruptcy, you can't, give all your money to one creditor, be it a spouse, CRA, or anyone, and ignore your other creditors. Those other creditors get to come forward and say, unwind that transaction, reassemble all the assets under Wesley Jackson's name, and let's now go in the order of priority set out under the Bankruptcy and Insolvency Act. And there's a very specific order in which creditors are entitled to take pieces of that pie. CRA is always number one, secured creditors number two, unsecured creditors number three. So I just wanted to fill that in for people who aren't familiar with that legislation for you.
Totally. Not only the Bankruptcy Insolvency Act, but in fact the Assignment and Preferences Act, which you were kind enough to. Were you talking about the Assignment and Preferences Act there, or were you talking about the BIA? I'm sorry, I missed that.
The way in which they work together.
Because they're both saying the same thing, which is if you try to evade creditors, the courts can unwind those transactions specifically because you're not allowed to evade those creditors, which is exactly what I was pointing out. It's illegal to do that aspect, and no lawyer should be counseling their clients to do that.
If I can point out sorry, if I can point out, hang on, I'm getting bounced back here. If I can point out one extra detriment of going for lawsuit, your name will be published as a defaulter on CanLII, and that can affect all your future real estate transactions if you decide to recover and want to get back into buying pre-con, or even just your own personal residence. Agents on multiple offers are now searching that. They're searching Geo Warehouse. They're searching everything to see what type of a buyer you are.
That's true. So long as it gets to a final judgment position and that you haven't settled during the course of that process, any judgment rendered is public. Absolutely. You're absolutely correct. Sanchita asks, can the builder put some sort of notice lien or something on the purchaser's other properties? To be clear, well, Sean answers it. But the answer is that until you receive a judgment, in the normal course of things, a standard agreement of purchase and sale new build does not ascribe a contractual right to tackle other properties. It merely gives them a claim at law, which until converted into a judgment does not attach to any attached to any other properties in the normal course, unless there's a varied contract that I'm not familiar with. What other questions, guys? Anything else?
Hey, Mark, how are you? It's Tom.
Oh, what's up?
Good, long time. From your experience, how many of the closings that you're having now are having issues with appraisals, the pre-con closings?
Well, I don't know what the aggregate amount is because embarrassingly, I don't have a proper CRM that's able to pull up that exact figure. I shouldn't admit that because it makes me look less than competent perhaps, but there it is. So I don't know what the aggregate amount is or even the percentage amount, but I will tell you, our firm deals with about 150 deals now per month. That's roughly what we do. We are failing to close now probably I have about 4 probably per month that are failing to close in the past several months, and discussions every day, because these discussions are not about closings that are happening that day or that month, but rather this year. Like we're just having endless discussions because these things are coming up and everyone is preparing for it. So I'm getting the sense that we are in advance of a massive flood that is only just beginning. Does that make sense?
Yeah.
But I don't have actual numbers. If
Well,
maybe other lawyers want to share, but there it is. I can't speak to your exact answer.
2018 on the assignment market that are losing 200K, they can't close because the appraisal came back lower. And this is a 2018 purchase, which you would assume that if you purchase something in 2018, it would be relatively okay in today's market. But still, people are having issues.
Well, it also really depends where you are, Tal, right? Like if you purchased in Caledon and you purchased a freehold, then you found that there's been a decline of 35-45% in value. Paris, Ontario went up massively and then dropped, which is very different than the GTA condo market, right? So it's really very market specific, of course. But the appraisal issue is a real one. We're getting it every single day. Babette, go ahead, please. Unmute yourself and feel free to ask.
Okay, I guess I have 2 questions. The first one being is in most of the contracts that I've reviewed in terms of purchase from new builds, you're not allowed to advertise for sale, But if you know you're going to have to breach that contract, and you want to mitigate because you might, if you start advertising now, you might be able to get the full price. How do you handle that in that contractually, the client's not allowed to advertise for sale or to resell it or to sign it prior to closing, yet at the same time, they know they're not going to be able to close and they want to mitigate their damages?
That's an excellent question. But are you a lawyer or are you a realtor? I apologize.
I am a real estate lawyer, but I don't do litigation.
Understood. So look, here's how I answer that question for my clients. And I have the same discussion with them all the time. By law, by contract, you are not allowed to advertise this product. And it doesn't matter if you're on a Facebook forum or if you're on MLS or if you are just sitting there and sending something out through WhatsApp. By the definitions of a normal standard agreement of purchase and sale, even with the right to assign, you are not allowed to advertise. Practically, I have never in my career, and I deal with assignments all the time, ever seen a builder object to an advertisement on an agent-only forum. You're all agents, you all practice in this space. Please correct me if you guys have contrary experience, but I would hazard a guess that absolutely everyone on this forum would agree with my statement. That is, even though contractually you're not allowed to do it, there is a commonly understood venue for advertisements that is acceptable to the builder class because it's not setting a market price. So because it's illegal, or not illegal, excuse me, because it is anti-contractual and yet people do it, the answer is very simple. Here's my dialogue. You are not permitted to advertise. You are asking me as a lawyer, and as a lawyer, I'm telling you are not allowed to advertise. Practically every person who's ever achieved an assignment has advertised on agent-only forums where builders do not seem to have a problem. Should you be the first test case where they have a problem, there's nothing I can do to defend you because you're contractually obligated not to do this. You'll have to take a business risk as to whether to do it. Remember, we're mitigating through breach of contract, not illegality. Having said that, your risk is relatively small, predicated upon the experience of tens of thousands of people who have assigned their product in this very way. Make your decision. And no one then turns to me and says, I really want to abide by the contractual terms. They all go ahead and find an agent and they go ahead and do it. But that's the way you have, and that's the way, by the way, agents should do it. And everyone should be doing that in writing so your ass is covered.
Okay. And a quick question. For you talked about a summary or default judgment on like a power of sale. If you get a judgment, can you get a writ of execution on those, or do you have to do another process to get that registered?
Well, that's really more power of sale than it is
breach of contract.
than
Okay.
it is what we're talking about here. Do you mind? Just ask me that question afterwards, and I'd be happy to. I'd be happy to go through it with you if you want the power of sale process.
Thank you.
In fact, actually, we actually had Matt, just so you know, Matt Gibson did a tremendous talk for us, which is in our videos on the power sale process, exactly how it works and everything else. I do strongly suggest you watch that video.
Okay, I'll reach out to find out how to get that video.
No problem. It's right at the top. If you go to our forum, right at the top on one of the pinned things, there's our YouTube channel. If you click on it, you'll see all of our previous videos.
Thank you very much. Thank you.
Guys, 5 more minutes. Who has any other questions? I'm hanging around for 5 more minutes. You have 5 more minutes of listening to the beautiful sound of my voice. All right. Well, it looks like you guys are as sick of it as I am. So there we go. All right, guys, listen, thank you very much. I appreciate it. This will be up. We'll put it up so that you can show your friends, read it to your kid, read the transcripts to your kids at night. I don't know what you're going to do with it, but regardless, thank you very much for attending. And we have a couple of other really cool talks that are going to be coming up. I'll announce them once we have them done, and they're going to be with third-party experts in the field. As always, I'm looking forward to a great 2024, and thank you all for attending.